matter of URS Corporation Limited against BDW Trading Limited.
Lord Burrows will hand down the judgment.
On June the 14th, 2017, Grenfell Tower in London was engulfed in flames and 72 residents lost their lives. The main reason for the tragedy was the use of unsafe cladding on the outside of the building. Investigations led to the discovery that many high-rise residential buildings across the UK were subject to serious safety defects. The government encouraged developers to carry out any necessary remedial work for safety defects discovered, and this was reinforced by the imposition of legal liabilities on developers by the Building Safety Act 2022. It's against that background that the dispute arose between developers and design engineers with which this appeal is concerned. The Respondent, BDW Trading Limited, is a major property developer. Its brand names include Barratt Homes and David Wilson Homes. The Appellant, URS Corporation Limited, provides consultant engineering services. During its post-Grenfell investigations in late 2019, BDW discovered design defects in 2 sets of multiple high-rise residential building developments for which it had been the developer and for which the structural designs had been provided by URS. In 2020 and 2021, BDW went ahead and carried out remedial works to the developments, albeit that at that time, BDW no longer had any proprietary interest in the developments and no claim against BDW arising out of the defects had been intimated by any of the development homeowners. BDW did so because it was concerned that the defects, if left unremedied, presented a danger to occupants, and there was also a reputational risk. BDW then claimed the cost of those remedial works, that is, the repair costs, from URS in the tort of negligence. There was a trial of preliminary issues before Mr. Justice Fraser, and he held that BDW's claim in negligence should not be struck out. At that time, any claim by BDW against URS under Section 1 of the Defective Premises Act 1972 would have been time-barred because more than 6 years had elapsed since the completion of the developments. However, under the relevant provision of the Building Safety Act 2022, which came into force in June 2022, the limitation period for claims under Section 1 of the Defective Premises Act was retrospectively changed from 6 years to 30 years. As a consequence, BDW applied to make amendments to what it had claimed so as to bring new claims against URS under Section 1 of the Defective Premises Act and also under the Civil Liability Contribution Act 1978, which I shall refer to as the Contribution Act. Those applications to amend succeeded before the Deputy High Court judge. URS unsuccessfully appealed to the Court of Appeal against both the preliminary issue and the amendment application decisions. URS now appeals to the Supreme Court on 4 grounds, which deal respectively with the tort of negligence, with the new retrospective time limit under the Building Safety Act, with the scope of Section 1 of the Defective Premises Act, and with the law on contribution under the Contribution Act. The Supreme Court, sitting as a panel of 7, unanimously dismisses URS's appeal on all 4 grounds. The leading judgment is given by myself and Lord Hamlin, with whom Lord Lloyd Jones, Lord Briggs, Lord Sales and Lord Richards agree. Lord Leggett gives a concurring judgment, and his judgment is of particular importance on the contribution ground because he sets out the reasons on that ground that are agreed with by the rest of the court. Turning to the first ground of appeal, URS's essential argument was that they were not liable in the tort of negligence for the repair costs incurred by BDW because those costs were voluntarily incurred by BDW at a time when BDW had no proprietary interest in the developments. Those repair costs were, so URS argued, outside the scope of URS's duty of care or too remote, and were therefore irrecoverable as a matter of law. The Supreme Court rejects that argument. There is no such voluntariness principle. The 4 cases relied on by URS do not establish that principle and are to be explained in other ways. It may be that a claimant's voluntariness is relevant to legal causation and mitigation as being concerned with a claimant's unreasonable conduct, but it's not in dispute that in this case, the application of legal causation and mitigation is fact-specific and must go to trial and cannot be the subject of a successful strikeout by URS. Ground 2 is concerned with the effect of the retrospective time limit of 30 years for claims under Section 1 of the Defective Premises Act, introduced by Section 135 of the Building Safety Act. URS argued that that time limit had no impact on the claims in the tort of negligence or the law of contribution. The Supreme Court rejects that argument. When the relevant words used in Section 135 are considered in the light of their context and the purpose of the statutory provision, they should be interpreted as applying in the circumstances of this case. That is, they apply where, as in this case, there is a claim for damages for repair costs in the tort of negligence, or there's a claim for contribution in respect of those repair costs, and it's contended that as a matter of law, the repair costs are irrecoverable as voluntarily incurred, or that there was no liability for the same damage because the claim under the Defective Premises Act was time barred. The effect is that there was no relevant time bar at the time that the repair costs were incurred. Section 135 does not, however, retrospectively affect any issue at trial as to the reasonableness of BDW's actions in carrying out the remedial works as a matter of legal causation or mitigation. Ground 3 is concerned with whether URS owed a duty under Section 1 of the Defective Premises Act to BDW. Clearly, a duty under that Act was owed by both BDW and URS to the homeowners in the developments, but was a duty owed by URS to BDW? URS argued not. The Supreme Court disagrees. Again, looking at the words used in the light of their context and purpose, they should be interpreted as imposing a duty to any person, including a developer, to whose order a dwelling is being built, who will ordinarily be its first owner. Here, relevant work was carried out by URS to the order of BDW, and URS therefore owed BDW a duty under Section 1 of the Defective Premises Act. The 4th and final ground of appeal focuses on the law of contribution. The Contribution Act gives a person, who you can call D1, who is liable for damage suffered by another person, who we can call C, a statutory right to recover contribution from anyone else, D2, who is liable for the same damage. In this way, the cost of compensating C can be allocated between D1 and D2 according to their relative responsibility for the damage that C has suffered. Here, BDW, that's D1, having carried out the repairs, has claimed contribution from URS, that's D2, under the Contribution Act on the basis that BDW and URS are each liable to the homeowners, C, for damage resulting from the defects. Contrary to URS's arguments, BDW is not prevented from succeeding on a claim for contribution against URS under the Contribution Act by the fact that there's been no judgment against BDW or settlement between BDW and any of the homeowners, and no homeowner has ever asserted any claim against BDW. It is sufficient that BDW has made a payment in kind by performing remedial works in compensation for the damage suffered by the homeowners. URS's appeal is therefore dismissed on all 4 grounds.
Thank you. The court is now adjourned.